We've just seen a major Supreme Court ruling that's seriously shaking up the rules on workplace safety here in India, especially inside its massive government departments. So let's dive into what this landmark decision really means, because it redraws the lines of justice for people who work in completely different worlds.
I mean, think about it. It's a question that opens up this huge legal gray area. If you work for one government department and you're harassed by someone from a completely different one, who investigates? Whose rules apply? That's the exact puzzle the Supreme Court had to solve.
And believe me, this was not a quick fix. This whole thing kicked off with an alleged incident back in May 2023, and from there, it just climbed the ladder. It went from an internal committee to the Central Administrative Tribunal, then the Delhi High Court, and finally landed right at the top in the Supreme Court.
Now, to really wrap our heads around the court's decision, we first got to understand the players involved and just how separate their work lives really were.
Okay, so this is where the problem really comes into focus. The person who filed the complaint is a senior IAS officer in the Department of Food and Public Distribution, and the person she filed it against? An IRS officer working for the Central Board of Direct Taxes. You see, both are high-ranking officials, for sure, but they operate in totally separate administrative universes. We're not just talking about a different office building. This is a whole different government department.
And that complete separation is what created the central issue, what we're calling the jurisdictional puzzle. Which department's Internal Complaints Committee, or ICC, even has the right to hear the case? And this led to two completely opposite arguments. On one side, the respondent said, hey, only the ICC in my own department can investigate me. But the complainant argued, no way. For this to be fair, for me to even have a chance, my department's ICC has to have the power to look into my complaint. So the same law was being read in two totally different ways.
So, how did the court solve this mess? Well, they did more than just read the words on the page. They went deeper to decode what the law was actually trying to achieve in the first place.
The court started from this really powerful idea, the Prevention of Sexual Harassment Act, the POSH Act. It's not just a set of rules. It's what's called a social welfare law. Its whole reason for existing is to protect women's fundamental rights to equality and a life with dignity. And looking at it through that lens, well, that changes everything.
There's a legal concept for this. It's called purposive interpretation. Here's an easy way to think about it. Imagine a sign that says, keep off the grass. A literal reading just means don't step on the grass, right? But the purpose is to keep the park beautiful for everyone. The court did the same thing here. It looked past the literal words to find the law's true goal, creating workplaces that are genuinely safe for women.
And you know what? The law itself totally backs up this big picture view. The official definition of a workplace in the Act isn't just your desk or your office. It's written to include any place an employee goes as part of their job. That alone tells you the law was never meant to be trapped inside departmental walls. All right, now this is the little phrase that caused all the trouble. Section 11 of the Act has these 6 simple words. The respondent's whole case was built on the idea that the word where meant a physical location, his office building. But the Supreme Court looked at that and said, hold on a second. They asked a different question. Is where about a location, or is it about a condition? And they came to a groundbreaking conclusion. It's not about geography at all. In the context of this law, the word where actually works just like the word if. And when you actually look at the full section, the court's logic is crystal clear. The text lays out 3 different scenarios. It makes perfect sense if you read it as, if the respondent is a government employee, you do this. If they're a domestic worker, you do that. The word where is obviously setting up a condition. It's not pointing to a spot on a map.
So after decoding the law's true intent, the court didn't just stop there. They went on to create a clear, practical solution for how these tricky cases should be handled from now on. They laid out a simple 2-stage inquiry. First, in stage 1, the complaint goes to the ICC in the woman's own department. They do the initial fact-finding. This is so important because it makes the whole process accessible to her. Then, if that inquiry says, yep, something's here, the report moves to stage 2. It gets sent over to the respondent's department, and their committee handles the official disciplinary part of it.
And that's the real genius of the solution. See, it's not about one side winning. It makes sure the victim has a clear and accessible way to get justice, while also making sure the respondent is judged by the disciplinary rules of their own employer. It's a system that's actually built to be fair to everyone. At the end of the day, this ruling is so much bigger than just two government officers. It sends a powerful message that's going to have a ripple effect on all kinds of workplaces all over the country. The impact here is huge. It completely removes a major roadblock for victims. It clarifies that, yes, employers have to cooperate across departments. And, most importantly, it closes a really dangerous loophole in the POSH Act, bringing it back to its original mission, protecting women and ensuring dignity at work, no matter where that work actually happens. And that kind of leaves us with one last big thought. This ruling creates a clear path forward for government workers, but the ideas behind it, accessibility, cooperation, and focusing on a law's real purpose, those are universal. So the real question now is, how can we take this same logic and apply it to make every complex modern workplace safer, from giant tech campuses to the gig economy?